I want to record to the cloud, which now we are.
Sounds good. Good morning, Aurelia. Kevin? Who's Kevin?
I don't know, actually.
I can answer that question.
Okay.
So Kevin Gregg is our rules coordinator for the
Oh, good.
corporation division, and he is going to also be my backup. So that way I don't miss anything going forward.
Great.
And he'll be checking, make sure I'm doing my work. But also today I have to leave a little bit early, so he'll be able to fill in for me when I go at 10:30.
Thank you, Jamie.
Thank you.
I really appreciate everybody taking the time to do this today. It's been a while since we were able to get together, and so it's good to start off the new year re-engaged and getting this ready for 2023 session. So, okay, so hi Jeff, glad you're able to join us briefly. So Sandy and I were talking, and John and I were exchanging emails about re-engaging with this group and making sure that everything is cleaned up and ready to go for Legislative Council. And so Sandy and I talked a little yesterday. Sandy, do you want to just sort of walk through what timeline looks like for the group?
So, you know, I can say this is aspirational, but I think it's also realistic. What we hope to do is finish off the last couple sections, which hopefully won't take too long, of just our general overview. Then today, hopefully we can finish that today, maybe with a little spillover into the next meeting, which we want to schedule. Yeah, we're going to try to schedule at least 2 meetings today or moving forward, just so we have that on track. February, what we want to do is with a meeting check-in, we want to spend that time really collaborating our work into one place, and I'll provide resources to do that in terms of a shared document, so everyone can put their in their sections to make sure that we have a draft that we can look at together of what we've agreed upon, and then areas that we still need to go back and make sure we finalize our decisions before it eventually gets turned over to Legislative Council to drafting. Legislative Council, I know from speaking with them on a different project, from pretty much today through the end of February are completely booked with the short session, which is okay because it's not a time where we were planning on where they were going to be able to do a lot for us anyway. But we can have as much done possible prior to the first couple weeks of March. Then what we'll be doing in the background, and this is Valerie and John and I, is working with Dexter Johnson and everyone to make sure that the right people in LC are ready, that they know it's coming, and that they will give us a timeline of when they have our work of what the Legislative Council's version is going to look like. We really, really hope by middle of summer. That's sort of the idea. At sometime in the range, July. I'm being hopeful, but realistic. At that point, once we have their draft, we can review back to make sure that we're probably not going to agree with everything, but that we can live with what is there and suggest changes within the LC, go back and forth. And then in the late summer, early fall, to make sure that to approve it on our end, to make sure that we have a draft that we're comfortable with to then work with to get it on the legislative calendar for 2023. That process starts September, but we want to make sure we have it to them by November. And I'll be in touch with our partners with Judiciary Committee and the legislature for the 23 session up until that point. Then we just spend any time we need to receiving feedback from the business community, the various lobbying entities, whoever needs to make comment, to ask for tweaks. We might have to come back and convene. We've had to do that in other bills in the past with the commission. If there's a particular section that a interested party says, nope, we're not going to let go, we are going to block, that could happen. We hope not. But if so, we might have to be a bit flexible during that time. This is late. This is now talking about late 2022 into very early 23. And then the idea is that we have a bill that's ready to go then for the long session. When hearings start, that's probably going to be in the February, March range of 2023. So that's kind of the sketch out. I think all those timelines are realistic, but we also are going to need to be able to pivot, especially if there are sections that we don't anticipate, which raise a big time red flag with an interest group or with Legislative Council. So things to keep an eye on right now.
So And so that's the process with respect to the bill. The other part of this is going to be education of the practitioner community, as far as this is a very big change. You know, I think that if we get the groundwork laid correctly, we should be able to anticipate that it will pass in substantially the same form that we have here. You know, Sandy said maybe with some minor tweaks. But I think we want to get out ahead of educating the practitioner community and at least starting to pull together materials to help do that. So, you know, to that end, I've asked my law clerk to start putting together a series of memoranda that address sort of key areas where this act diverges from other, you know, where we are now. But, you know, I think it's going to be important for this group to be involved, and frankly, good marketing for everybody involved in educating you know, when this does pass. So we want to have our materials ready to go. I know when they had the prior version of this, the group put together a workbook of here's the changes, basically. I know this because I've seen it in Michael's office. So so I think we want to think about doing something similar to that. You know, that will at least be some useful tools for people moving forward. So we can talk about that over the course of the next few sessions that we get together. But I wanted to sort of set the stage because I think some of our attention is going to be focused on dealing with legislative process. But really, for most of the people in this group, that is not our highest and best use. You know, that is going to be much more in John's court than like mine, for example. So you know, we're done with the heavy lifting, but now we have to think about how do we communicate where the changes are and what this means for practitioners, both on the CPA side and also on the attorney side. So, okay, so that's sort of what I'm thinking. And then, well, we have Jeff here. I'd like for us to get the next two sessions on the calendar. And I was thinking maybe February 10th in the morning. That's another Thursday. Does that work for people? Is anybody violently opposed to the idea of February 10th? Okay, so let's plan on February 10th for the February meeting.
Valerie,
Yeah.
sorry, I couldn't get the mute. I will be, that's when I'm on vacation. I mean, don't hold up for me, but I won't be able to make February 10th.
Okay, and then what about March? What does March look like for you? Are you back?
Yeah, we come back, what is it, the 16th of February. So March should be fine. Go ahead,
Okay.
set a date.
Okay, so what about March 10th then? So it's another Thursday because of course the way the calendar works. Good, let's do that.
Works for me.
So wait, I'm sorry, it was March 10th?
Yeah.
That's fine, both those work.
Okay. Good. So I think that'll make things easier going forward because we'll just have it back on the standing calendar.
I'll get those calendar invites out today for both.
That would be great. Thank you. I appreciate that. Okay, and so that's sort of the timeline. Does anybody have any thoughts or concerns about the timeline or questions, things that we need or not thinking about? Okay. Good.
I was just sorry. I just wanted to that all sounds fine. I had a question about just in terms of the timing, what work is left to be done.
Yeah.
Because we're still in the middle of the Article 10, right?
Well, I think we've finished Article 10 except for the definition section at 10:01. I think I was looking through this yesterday and I think we had finished everything else. And then Teresa had taken care of section 11.
Mm-hmm. Yeah.
So
one thing I guess I thought there were several sections that we had sort of punted either because we needed information from Secretary of State still or some other person or group that we needed from. There was some sort of political footballs we had punted. And then one other thing I noticed is there's a lot of provisions in ORS Chapter 63 that don't have a counterpart in ROLCA that we haven't discussed. And it struck me that we ought to discuss those.
Yeah, that makes sense. And probably you and I should talk offline about what those are. And then we can bring that to the group for the next session for
So
the.
Valerie?
Yes, sir.
From time to time, just to Cody's point, you've said, well, let's put a pin in that. Do you have a list of our pin?
I think we circled back to most of them. We did, so David's going to talk about 102 today, because that was definitely one of the sections that we said we're going to circle back on this. And then I wanted to find out if the group wanted to review any of the operating agreement provisions in light of the discussions that we've been having to date, because we went through it, but I think when we went through it, that was definitely one of those, are we going to revisit this after we've had a chance to look at everything else in the act questions? So were there other sections that people were concerned about? I mean, I think as part of scrubbing through revisions, we're going to find some other provisions that we need to revisit in light of what we've all been talking about. But I just want to make sure that we've done a pass through all of the major sections. And as far as ones that we haven't really talked about at all so far, I think it's 1001 and 102 is what I've got on my list. Does that sound right to people?
I think so. In terms of what we talked about it. True.
I think that's accurate as well. The one thing I do think that we actually have talked about sections of the ORS that we want to keep in, but I think what Cody's talking about would be valuable to make sure we've caught all of them.
Yeah, I agree.
And I was going to add, has anybody gone through and figured out what they are? Cody, have you? I mean, how do we kind of need a list of what they are so we can discuss them?
Right.
Yeah, I have done that. I mean, I could mention them now, or Valerie had said doing it offline later. I'm fine either way.
Yeah, Jeff, why don't we circulate a list for people so that everybody has a chance to prepare for the next meeting?
Yeah, I think, if Cody could send maybe just a list of the sections that haven't been addressed, and then, pick a time to review them. But I agree with David and Cody. We should look at that.
I know when we were talking about the liquidation and dissolution statutes, there's a number of those sections of the ORS that need to go into the bill that we're going to propose.
In what section, David?
But when we talked about the liquidation dissolution, right? There were some
and that's why I think the process of going back over the whole act more quickly than we did the first time, obviously, but I think that'll be an important part of making sure that we've hit everything.
I think on occasion we punted to legislative council on some issues. So
right, and we should be clear that that's what we're doing. I think in our notes and our annotations to the draft. What is that? Somebody's getting feedback. Okay. All right. So with that, I mean, I think that's at least what I'm thinking as far as a plan. And of course, as with everything in 2022, that's subject to change. We are bringing new understanding of the term flexible and pivot and all those things. So, okay, so let's start off with section 1001, because, we had, David and I had originally taken this section with the thought that we were just going to not adopt Article 10. And I think the discussions that we've had on the remainder of Article 10 have changed my thinking on that. And so going through it, there's a lot of terms that I think are fairly non-controversial based on the discussions that we've had about other sections. So, and this is on page 176 of my printout of the draft, section 1001. So basically it's the general provisions and definitions. So acquired entity, acquiring entity, conversion, converted entity are all terms that are, fairly non-controversial within the subsequent sections of section 10. It's only when we get to, I think, the definition of entity that we explicitly decided that we wanted to adopt definitions in 63-467. So 63-467 is the definition section for LLCs, and for the merger provisions of LLCs. But they only define this ORS section only defines business entity, organizational document, and owner. So there's obviously a lot more definitions in the revised act than there were in our original version. So, I think what we had decided was to wholesale take out the definition of, both parts A and part B of in 63-467. So that says that business entity means any of the following for-profit entities. So professional corporation corporation, limited liability company organized under this chapter or comparable law of another jurisdiction, a partnership organized in Oregon after January 1, 1998, or that is registered as limited liability partnership, or that is elected to be governed by ORS Chapter 67, and a partnership governed by a law of another jurisdiction that expressly provides for conversions and mergers. Now that language right there, I don't know, because that language is, I think, limiting in the sense that we're, the new section 10 addresses more than just conversions and mergers, right? Because we have the domestication provision. So I think we want to include, make that language, either we want to get rid of the reciprocity requirement, or we want to expand it to encompass everything that is within section 10. Do people have any thoughts about which way we should go?
One thing I'm just thinking is we're kind of looking at where we are now as a state, but the plan is to go forward with a lot of the other uniform acts. For example, we don't have a limited liability, limited partnership, but we could end up with something like that in the future. So
no, Jeff, I'm talking about when we talked about this, we had decided to move forward to essentially take the definition in section 11 and replace it with the definition in 63-467 for business entities.
Yeah.
Because we can always revisit this. And this actually goes to some of my comments about some of these other provisions where, we're out ahead of a lot of the discussions on about where we're going with the other acts, right? And so a lot of the language in the definitions in this definition section, presupposes that we've adopted all these other acts. So I think that the terms that we have in here, as far as business entities, need to carry forward to, for example, the definitions in governor. So because we can't, as this work group, go changing the terms for what the person who's in charge of running a corporation is. But if you look at the definitions on page 179 of governor, they basically make governor the person who is in charge of running all these other entity types. So I think when we go through those definitions, we need to be thoughtful that, to the extent that the Corporations Act gets adopted or some of these other acts get adopted, they're going to have to come back and update the definitions in this section to expand the definition of governor, to expand, certain of these definitions.
Well, that addresses my thought then, is we come back and retool it later.
That's sort of what I'm
for today, and then retool later when things change.
That's what I'm thinking, because I think we're going to get pushback if we try and change in the LLC Act, what the Corporate Act does without revisiting the rest of the Corporate Act.
No, I think you got to look backwards and not look forwards in terms of those kind of changes.
Yeah.
Because we're at the front end of all these changes, of all the acts.
Yeah, so for purposes of the definition of entity, I think we decided to stick with what we have in 63-467 for now, but then, we can expand it later as these other acts are revisited. And of course, that takes us to the middle of page 178. And I think filing entity is fine, foreign is fine. And this definition of governance interest is going to be tied to our understanding of the definition of governor. But I think when we get to the definition of governor on page 15, what my suggestion would be that we only change governor to be what is current in this definition of E and F, and then not have, and maybe K, depending on what the group thinks. but not have all of these other persons, fiduciaries, because those are all implicate other acts. Does that sound reasonable?
I don't know. So I don't know if that we can do that, because a lot of these provisions are contemplating the possibility that an LLC may, for example, merge with a corporation, and so we need to have language that accommodates that possibility. And if we delete, for example, 15A, governor means a director of a business corporation, then what does governor mean when one of the parties to the merger is a corporation?
Then you would have your corporation would still have their directors, and your LLC would have their governors. So the definitions that are current within the acts that we're not monkeying with at this point would still remain. You know, and then to the extent that they're updated by a future work group, then you can go back. And that's what I was telling Jeff. So I think we would go back and update this definition to expand the definition to include that governor section.
So is the issue that governor is not used in the Business Corporation Act?
Right.
Well, I don't think this provision is going to affect anything in the Business Corporation Act. I think these definitions, and I'll have to go back and see how governor is used in Article 10 of this statute, but a governor is used to discuss what happens in Article 10 of this statute. And so I don't think it's going to change anything that happens in ORS 60. Am I mistaken on that?
I agree with most. And if you have a defined term in the LLC Act, and that term is governor, and the only time that word is appearing is in the LLC Act, then it is not going to affect anything in ORS Chapter 60, so long as that's Chapter 60 exists. The problem would be, let's say, if Oregon doesn't call a director of a business corporation a director, if we have some other name for that, then we would need to change the word director or trustee here. Or if any of these A through J are an inaccurate description of how we refer to the governors of those other entities, or maybe we don't have a particular one of those entities in our statutes at all, I would think we would need to delete those or change those titles. But just because we have a defined term here that sort of is envisioning a future expansion of the hub and spoke model doesn't mean it detracts from our current versions of spokes that we haven't adopted yet.
Could this be addressed in the drafting? Something along the lines of putting in an or equivalent position as defined in Chapter 60. Could that be done? And then that would be pretty easy to take that out.
Yeah,
or even just leave it in if Chapter 60 changes. Because
this is the problem, right? Where you have two people looking at the transaction from different sides of the wall. Right, where you have, it looks like a governor from the LLC side of the wall, and it looks like a director from the corporate side of the wall. I mean, I see your concern, Mohsen, and that we have these terms and the potential for someone, but you know, I guess my thought is that would that person not have a title for purposes of the LLC Act if we take them out of the governor definition? I mean, would it create confusion in, for example, the conversion statutes? If we were to say, okay, for right now, we're not going to call you a governor.
So does anybody know how the state of Washington dealt with this issue? I confess I did not look at that. But you know, when you do a search for a corporation in Washington or any entity, they list everything, all the people involved are listed on the website as governor.
Right.
And I don't think they've actually done anything recent with their Corporation Act, but I could be wrong on that. So maybe it'd be interesting to see how they handled it.
Yeah.
So, you know, I'm noticing, for example, and I just did a word search for governor in ROCA. And one example where it comes up is in section 1026, effective merger. And there it talks about in 10A10, no, just in B. It says, except as otherwise provided in the organic law, organic rules of a merging entity, merger does not give rise to any rights that an interest holder, governor, or third party would have upon a dissolution, liquidation, or winding up of the company, or winding up of the merging entity. So you're talking about a merger of two different business entities, and it doesn't give rise to certain rights of a governor. But if we limit the term governor here to essentially exclude a director of a business corporation, then you might have unintended consequences if you have a merger of an LLC and a business corporation.
Yeah, that's fair.
That's just, I mean, that's just one example. I mean, theoretically, to do it your way, Valerie, we could maybe like have a comment that says this catch-all in ROLCA K, until we adopt the rest of the hub and spokes, it includes all the, letters here in ROLCA that we're not adopting now, but that may potentially create more confusion than it heals.
Yeah, I mean,
So Cody, were you looking at this comment? Because there's apparently a comment, and if I could figure out what page, on 187 of ROLCA, that explains that they just choose the term to refer to a person who has the authority under the entities. I don't know whether that's where you were looking or not, but it
No,
seems.
I mean, yeah, I wasn't looking at, I was trying to look at like where in the non-comments, where in the positive law is it talking about, where does it matter whether you're a governor or not, and because of that, it would affect your rights.
yeah, I like Roberta's suggestion, where we put in a reference then to, the ORS chapter. So for example, you would say 15, governor means a director of a business corporation under the Business Corporation Act, Oregon Business Corporation Act, something like that. So we've got a cross-reference. So if that changes.
I don't think a cross-reference will do it, because we need to account for the fact that there may be directors of non-domestic corporations that we engage in, for example, a merger.
Okay.
And so, right, so I think this is written this way purposefully to be generic and capacious, because any type of these entities could be a party to, for example, a merger with a domestic LLC.
Okay. Does anybody else have any other thoughts on?
Well, the comment does, I mean, I know it's just a comment, but the comment does seem to encompass that. It's just saying, we just use the word governor. And what the word governor means are people who can have this sort of authority, which would encompass, as Mosen says, the foreign entities or any type of entity with respect to a person or persons who have this sort of authority.
Right, and I think that that language from the comment is captured in section K.
Mm-hmm.
The K is the catch-all.
Right.
That basically describes the general rule that the comment is referring to, and A through J are just specific examples of the general rule.
Okay. Any other thoughts on that? Does anybody feel strongly then that we need to, well, okay, so I guess you've convinced me. So we would keep A through K as currently scheduled on page 179.
Yeah, one question, why is 15G bracketed?
I think that's if you don't have general cooperative associations. I mean, that's sort of been the drafting style throughout
We
this.
don't really have cooperative associations, but we do have cooperative corporations.
Right.
Well,
But
I
we're
noticed-
essentially saying with K that if you have the authority to exercise, to control an entity, you're going to be included in the definition of governor.
I have a question.
Michael has a comment.
Go ahead.
and I don't know if you said A through K, are we keeping B, nonprofit corporation?
Well, I mean, that's a question. Do you want, are we allowing
Because-
nonprofits to merge?
Well,
Converge and all the
if we're
things?
going to pick up 467, that doesn't include
I know.
nonprofits.
True.
And
So it
467
seems like
includes
striking B.
professional. Sorry, go ahead.
Seems like we'd be striking B if we're not going at this point to include nonprofits in the entity definition.
Yeah, I think Michael's right that, and I have to honestly think about this a little bit more carefully, but I think if we're adopting the entity definition of 4671A, then what's in the governor definition here needs to essentially match that. The entities that are listed under the governor definition need to match what we're allowing to be part entities that engage
Well, I
in
guess
Article
that's
10
a question.
transactions.
That's a question then. Do, you know, because we had made that decision about 463, 467 a while ago. How do we feel about that?
I think we need to include G because we've got in 467, we've got, I saw it in a moment, member or shareholder of a cooperative. Maybe that's just for owner. Maybe it's not in the definition.
Well, we've got 1B, 467, where it talks about cooperatives organized under Chapter 62 or comparable law of another jurisdiction.
I'm just to make my point, I agree with Mohsen. I think what we do in 11A, we should do in 15. In other words, they should line up with each other. Either we go back to existing or we do the new one, you know, the current ROPA version. I just feel like they need to be consistent with each other.
One question I have is,
a good enough sense of, go ahead, Mohsen.
I'm sorry. One question I have, and I just don't recall, or maybe I wasn't there. Why did we, at some earlier point, agree to take the business entity definition that already exists in 4467? It seems like we should, because it's restrictive. It doesn't account for all the types of business entities that are
Yeah,
out there in
no, that's
various
true.
jurisdictions, whereas the ROCA definition seems as exhaustive as possible.
Yeah, because I have a note in here saying that, you know, it would be easier for legislative council to pull over the current definitions, but it would be easier from a drafting perspective if we kept what's in this section 11, right? Because then it would match up all the definitions moving forward. So, you know, I don't feel strongly about it. I think it would add additional flexibility, for example. I mean, I think we do need to add in professional corporations, but I think that it would add in additional flexibility for, you know, nonprofit business planning to include nonprofits in here too. Because right now we're pretty limited in what we can do with nonprofits in Oregon.
Well, but that's where I was kind of headed, is to the extent we want to preserve existing Oregon law, you can merge a nonprofit corporation with a for-profit corporation, but I think the nonprofit has to be the surviving entity.
Right.
I'm looking at 65.484 right now, and there's some
Yeah.
kind of general rules about when you can merge. So I think we need to be careful about whether we're preserving existing Oregon law, in which case we probably need to take that stuff into account when we draft, or we're making a change, in which case we need to highlight that.
Well, you know, but you can't merge, for example, a nonprofit and an LLC, I don't think right now.
But keep in mind, these are definitions we're talking about.
No, I understand that, Jeff.
What to do and not to do are in other sections. And somebody
Right.
made the point about foreign entities, and some of these things may exist. I mean, I'm thinking we were thinking going back to 63 definition, because we don't have a lot of these entities right now, like limited liability, limited partnerships. But again, it seems logical to me as I think about it that we should go with the ROCA version here, because it's just they're just definitions.
Right.
My question with regard to this nonprofit's ability to merge or not merge, or if it has to be the surviving entity, I would think that we would leave the entity definition of ROLCA alone, but we would need to check then the merger provision in ROLCA and make sure that it is not the substantive portion, that it doesn't allow the thing that our nonprofit act. bans.
Well, it
Fair
doesn't
enough, but if
ban
you
it. That's
reference,
the-
if you reference the nonprofit in the definition, aren't you kind of creating a potential confusion?
Well, I
And
think
if there's no applicability.
it depends. Maybe the substantive ROLCA provision says any entity except for a nonprofit corporation can do X. You know, then
No, I don't think it's that limited. That's the thing is, yeah, because I think it, it just uses the term entity in terms of talking about mergers in this context, right? And so, it doesn't have quite the guardrails that we would for, with the current definition of entity.
I would
Why-
think then the solution wouldn't be to exclude nonprofits from the definition of entity, but rather to modify section 1021, which says what mergers are authorized, and add a little section saying, except for mergers that are excluded by ORS chapter whatever that governs nonprofits.
Well, and I don't think the nonprofit chapter, there's a lot of issues with the current revision of the Nonprofit Act, but I don't think that it specifically bans mergers, but I just think that it hasn't been contemplated up to this point. Michael, you wanted to say something.
Well, just making maybe a legislative history point here. When the legislature dealt with this, and you can see the section notation at the bottom of 467, they had a bill that went through all the entity acts and created a uniform process so that if you're doing a cross species conversion or merger, all the entity acts were at parity with one another. And you can see that in Chapter 80 of Oregon Laws 2003. So that's how the legislature dealt with it then. I'm just making that point that when we start down this road, and obviously we already have, it's spending a lot of time in Article 10, we are creating some potential disconnects. So, I don't know if we're going to get pushback from legislative council on that issue, but there is precedent in terms of how the legislature has dealt with these issues before, and that's to go into all the entity acts at once and update them. And maybe the legislative council would be willing to look at that as in addition to this bill. I think that's aggressive at this juncture, but I'm just trying to put what we're talking about maybe in a longer context here.
Mm-hmm. Yeah, that makes sense to me, Michael. And I do think that, there's a certain amount of reconciliation the legislative council is going to have to do once they get this act. But the question, I guess, for this group is, do we want to be prescriptive from the get-go, or do we want to put out the broader version, see what legislative council does with it?
I would
say
suggest, go
version.
ahead.
Although I think the definition of entity and governor needs to be consistent with what we have in our statutes today.
Why?
Well, because we don't have like a general cooperative association. I don't know, we have even a limited cooperative association. So I think it has to be consistent with what we've got.
Aren't we contemplating, though, that these exist in other jurisdictions that may engage in transactions with Oregon entities?
Okay, that might be a good point. Yeah.
For example, we don't have, and I don't really have a dog in the fight. I figure any hobbling of the definition sections here will mostly limit what transactional lawyers can do or force them to find workarounds rather than,
yeah, that's fair.
Actually harming people's rights so much. But let's say, for example, we exclude limited liability, limited partnership from our definition of entity here. So then when you read our statute about LLCs merging with other entities from foreign jurisdictions, you can't do a merger with a foreign LLP. You'd have to find some workaround for it because we excluded it from the definition of entity.
Yeah. Yeah.
Well, and I think part of our goal here has been to, we were talking before when we were talking about domestication, right? That, there's not an easy way to do it in Oregon, but there's a way to do it in Oregon with a workaround. So, at least when I think about what we've done with this whole Article 10, it's to try and simplify and make more transparent for people who want to engage in transactions, what those transactions might look like and what the process would be. Okay, so I guess do we feel strongly that we want to keep the current 467, or do we want to go with this version of ROLCA, the ROLCA version, which then I think we need to make all the definitions match going forward with the entity definitions? Thoughts?
I think the way the ROLCA is drafted is purposefully intended to anticipate all sorts of possibilities for the kinds of entities that exist in non-Oregon jurisdictions and allow those entities to engage in the kinds of Article 10 transactions with domestic Oregon LLC. So I think it's important to keep the definitions in Article 10 to the extent we can. The issue that I've seen identified so far is that evidently, which is news to me, a nonprofit corporation in Oregon cannot merge with another for-profit corporation unless the nonprofit is a surviving entity. If that's the case, then my question is, why is that the case? And is that something that is that a policy that we need to preserve in the statute so that you couldn't do the same thing, but with a for-profit LLC, with the for-profit LLC surviving the merger? I don't see an obvious reason why that should be the case. And so I would just keep the ROLCA definitions altogether.
Roberta?
Well, I agree with Mohsen to keep the ROLCA definition, but I'm not sure that even if we keep the ROLCA definition, that's not going to change the Oregon law that prohibits the way that things merge. So
no, excuse, what I meant is what I believe ROLCA will contemplate is that a nonprofit Oregon corporation could then merge with a for-profit Oregon LLC, with the for-profit Oregon LLC surviving the merger. Whereas right now you couldn't do that. My understanding from what was said earlier, I think James said it, that you can't do that with a for-profit Oregon corporation.
Michael?
I guess hearing the discussion, I'm sort of leaning towards keeping the ROLCA definitions. And I think it's helpful to note that looking at the operative definitions that we're talking about, entity and governor, they're not qualified with the terms domestic or foreign. Correct. As I'm reading that. So I think several have made the point that keeping the pathway open if you're dealing with a foreign entity that maybe is something that Oregon does not have, the limited liability, limited partnership, for example, but they exist in other states. Should we close off the pathway to that potential merger, for example? And so I guess hearing the input, I'm leaning towards let's keep ROLCA definitions. Okay. Kind of where I am myself.
That's what I'm hearing as far as the consensus, unless someone feels strongly one, in the other direction. We've already spent a lot of time going through the other provisions of Article 10 and sort of hammering out what those processes look like. So, okay, good. Well, that makes the rest of this discussion a lot easier. Governor, then, I think we just need to make the terms governor, interest holder, and then the organizational documents in 29 of private organic rules match up, public organic record, match up with the entity types in the definition of entity, because I think those are all sort of come off of those, what entities are we going to be describing here.
The only question I would have then is, should we add professional corporation to the list for all of those sections you just mentioned, or all those definitions you just mentioned? I guess that's more of a question for the transactional attorneys. I don't know why ROLCA doesn't include professional corporation here, maybe they assume that that's subsumed within business corporation.
Yeah, that's my intuition on that. But we could make a note for legislative council to see how they feel about that. If that's, because from my perspective, it's sufficient because you would have directors of your PC.
Yeah.
But,
the only time ROLCA mentions professional corporations is when they talk about which names are distinguishable, and it talks about how you would, look at whether it says corporation, corp, incorporated Inc., professional corporation, PC, etc. They otherwise don't ever talk about so I don't know how our law treats professional. Maybe our law defines a professional corporation as just a variation on a business corporation.
Yeah, it's a curious omission, Cody, but I don't think that's the case because the current LLC statutes definition of business entity calls out professional corporations separately and apart from corporations organized under ORS 60.
It does, yes, as part of the definitions currently in our act include one for a professional corporation and a foreign professional corporation as well.
I also think though that, when you have a new entity type that comes into being, people get really excited about it and want to make sure that they're distinguishing it from existing entity types, even when it may be a distinction without much of a difference for corporate purposes. So, I mean, I think it's fair to pose that question to legislative council. I don't know that there's anything in these definitions to my way of thinking that would prevent, the director of a PC from, doing all the things.
Yeah, and the definition of corporation in Chapter 60 just means a for-profit corporation incorporated under Chapter 60. It doesn't use the phrase business corporation at all. So maybe we just would leave it as business corporation, which is a term apparently not currently used in Oregon law, and just have a comment that notes that includes both Chapter 60 corporations and professional corporations.
Could we do that in the form of like legislative history or something to that effect?
Yeah,
well, I think Cody's comment about a note, but this is the sort of thing where, and I want people to think about this too as they're going through their own sections for revision, because we want to make sure that to the extent that we've had these little discussions about, nuance in the act, that we're capturing that in the materials that we're going to be disseminating for educational purposes, so that people understand this is what we're thinking as drafters.
Is there anyone involved, for example, with the definition of governor, is there anybody involved with a professional corporation who would be like the director of a regular corporation that we would want to have captured in this concept of director of a business corporation? Or is that, it's
That's
referring to
not
the same
called a
kind of
director.
person, right?
Yeah.
So maybe if we just have a comment that business corporation includes professional corporations, then that solves the problem of not having to add professional corporations or comments to all those other definitions.
Yeah, that makes sense to me. And again, if legislative council feels strongly the other way, I'm not opposed to including it, but I just don't think it's necessary.
If we've reached kind of a decision point on our discussion, could we have a recap? Because I maybe have lost the thread.
Yeah, so I had started out this discussion with our prior, my prior notes on this that said we had decided to change section 11 to just the definition in 63.467. But Cody and Mosen brought up the good point that, we have these terms used throughout the, section 10, and it becomes confusing for people if they're trying to come in and do the things if we change these definitions, because, and it wouldn't be necessarily changing the way things would operate under the Corporate Act at this point. Because if you look at the prefatory language to section 1001, it says in this article, so it's definitions only for purposes of what will become chapter 63A. But it makes it easier to understand the mergers, conversions, and so on and so forth sections of section 10. And from my perspective, the goal with section 10 is to create clear paths. And so to the extent that these definitions help create those clear paths, I think that it makes a lot of sense. And I don't think that, I think it's, these entities exist outside of Oregon too, right? And so it creates additional clarity for lawyers coming in to try and figure out how to do the things. So I think that's what convinces me, is that, we will still have corporate directors for the purposes of the Corporate Act doing the things under the Corporate Act, but it streamlines the language for purposes of this act.
So where we're coming down, if I understand this, is adopting the definitions in ROLCA for business entity and adding a note per Cody's comment.
Yeah, that's what I'm thinking. Does that capture where we are? Okay. Good. I think the rest of the definitions are pretty non-controversial after that point. Things like foreign and domestic are obviously only with respect to the borders of the state of Oregon. Although what that makes truly foreign interests, I don't know that we can call that alien or something, but we run into this on the tax side of things all the time. So anyhow, any other questions or thoughts about section 1001? Because I think the rest of these terms, like plan of conversion, plan of domestication, we've already talked about when we've talked about the sections that involve those concepts. Okay. And then David and I had talked about section 102, because I think we did decide pretty early on that we were going to circle back to it. It's not a very long section, but it's the definition section at the very beginning of the act. And David, do you want to walk us through?
Sure. So I think we can get through this pretty quickly. At least I think so. So in section 102, I divided my discussion into three parts. One is the definitions in section 102, for which there are similar definitions in ORS 63.001. Second, the definitions in section 102, for which there are not any similar definitions in ORS 63.001, and definitions in ORS 63.001, for which there are not any similar definitions in section 102 or in ROLCA, at least I couldn't discover anyway. So the first part of my discussion is with respect to the definitions, actual definitions in section 102. And by and large, I recommend the adoption of those definitions with a couple of comments. And I can walk through each one of them. The first one is the definition of certificate of organization. I think we had talked very early on, and correct me if I'm wrong, that we still wanted to use the word articles of organization as opposed to certificate of organization. So that would be one change. The commentary doesn't like that word, the word articles, but I don't think we can be persuaded necessarily by the commentary. So that would be one. Otherwise, the definition of articles of organization and certificate of organization are not materially different in the respective statutes. The definition of articles of organization is in ORS 63.001, subparagraph 2. Anyway, so I guess I would favor continuing to call them articles of incorporation unless people think otherwise.
Organization, right?
Yes.
Yes.
Okay, so so the next definition is the definition of contribution. And again, they're not materially different between the two. They are slightly different. The ROLCA one, I would argue, is a little bit broader in its definition. But having said that, I would still recommend that we go with the ROLCA definition unless there's some sort of policy reason why we would continue to use the current definition. And I don't see any policy reason for doing that. So my recommendation is we adopt the new definition of contribution.
Can we look at 402 and see whether that, because it cross-references 402, that definition of contribution? I just don't know if that's.
I did look at that. So okay. 402 includes property transfers, services to be performed, and other benefit provided. And the current definition says basically anything of value and that a person contributes, including cash, property, or services rendered, or a promissory note or other binding obligation, contribute cash or property or to perform services. So they're not significantly, I guess when I was reviewing this yesterday, I felt that the ROLCA definition was slightly more broad, but now that I restated, I don't know whether it is necessary, but the statutory definition here in Oregon, although includes some sort of goofy things like a promissory note, but I don't think that needs to follow through into the new proposed legislation unless somebody feels strongly otherwise.
I think whenever you have a list of things, even though it says including, there is some tendency sometimes for courts to limit to that list of things, and that we do not have that issue in the ROLCA definition. I do think that the best interpretation of including means including but not limited to, but it's not always viewed that way.
Well, certainly I wouldn't have any issue with that kind of change. I guess, we could go back and look at 402 again. When I looked at it yesterday, it seemed like it was very, very broad in its definition of what could be, given in terms of in exchange for a membership interest.
Yeah, and I think that probably was the intent, that it should be very broad.
Yes.
So I might suggest, if we're going to keep the ORS definition, that maybe we add it, but not limited to.
Oh, no, I'm recommending we adopt the ROLCA definition.
Oh,
Yeah.
are you? Okay, well, I'm fine.
Oh, yeah.
Okay, sorry, misunderstood.
No, that's fine. It's good conversation.
Right. So ultimately, I'm recommending, with the exception of the certificate of organization, that we adopt all of the ROLCA definitions. I don't see any reason. The other thing will be whether the real issue, and we'll get to sort of last, will be the definitions in the current act that we arguably need to go into our proposed bill. So the next one is the definition of debtor in bankruptcy. And interestingly enough, I searched through ROLCA. This definition is repeated one more time. and so I don't know, in that reason why they should have defined it in the other section, I think. But it shows up in section 602.8, which is one of the sections of 602, which sets forth what is an event of dissociation. So obviously, if you become a debtor in bankruptcy, that will be a event of dissociation. So there really is not a true analog to this in our statute, other than the definition of bankruptcy. And bankruptcy lists 9 events that constitute bankruptcy, which and those events of bankruptcy essentially that are listed in the definition are essentially in a much more abbreviated manner repeated in section 602.8. So I think that unless we wanted to add all those additional definitions, section 602.8, which I'm not recommending, that we keep this definition in, although I think it's kind of redundant to some degree. But more importantly, we do not include the bankruptcy definition in the current act, and I don't see any value to that. Anyway, so that's my thought on that. The next one is the definition of distribution, and the similar statute in Oregon is ORS 63.0016. The definition of distribution is quite a bit more expansive in the ROLCA compared to what is in subparagraph 6 of 63.001. But, I would argue in a way that they're not materially different. They just, they go out of their way to include in the ROLCA definition some things that are not included in our definition, but probably would definitely be that way. Or could be, our definition can be interpreted to include that. The one that they talked about the most in the commentary was a redemption or other purchase by a limited liability company of a transferable interest, which is a defined term, and the like. But I think it's sort of included in our definition in any event, which includes a purchase, retirement, or other acquisition of interests, that sort of thing. But again, going along with our sort of decision to go with ROLCA unless there's a policy reason to go with the act. My recommendation again would we adopt the ROLCA definition of distribution.
So David, why in the ORS does it say except of a limited liability company's own interests? I don't know why that's in there or what it means, and if it's significant in any way.
So I don't know what that means either. Actually, I looked at that and I'm not quite sure what that means. So, so to some degree, we get rid of the confusion by not including that as part of our definition. So that I don't know. You could distribute. I guess you can't in Oregon distribute. So membership interests, it would not be considered a distribution. So, but although I think in a corporate side, you could have a distribution of stock would be a distribution or an issuance of stock.
That's an issuance, yeah, not a distribution.
So maybe that's what they're getting at here. So that would be similar to. So
To Roberta's earlier point, do we want to include but is not limited language after includes an A?
for which definition?
Distribution.
I don't think we need to do that because I was confused. I thought David was trying to adopt the ORS definition.
Right.
No, but in 4A, it says the term includes, and then it goes into the language about redemptions. I mean, do we generally want to put that in there? I don't feel strongly one way or the other, but you'd mentioned it, so I just thought I'd ask.
I wouldn't have any objection to that, but keep in mind that the ROLCA definition also has an exclusion.
Right. So maybe not then.
Right.
Okay.
And the commentary made a big deal about that exclusion for whatever it's worth.
I just wonder if anybody knows in this group what that except of a limited liability company's own interests. And I mean, in the corporate context, wouldn't a stock dividend be its own interest? And that's not an issuance, right? If there's a stock dividend, maybe it is. I don't know.
Yeah, I know. I kind of agree with you. So I'm not quite sure what they mean by that either. It's never come up in my practice. Question has never come up before. I think in an LLC, I don't think we've ever distributed an LLC interest as a distribution. At least not to my knowledge. So.
I'm fine with that definition in 4 though, unless anybody feels strongly.
Am I reading this right? The ORS talks about it's a transfer to or for the benefit of a member, whereas ROLCA talks about to the person. I mean, I know they say person rather than member, so I guess that instead of the reason is that, I mean, are they capturing because they say to a person rather than to a member? Is that intended to capture the same concept?
I think so. So I think the other thing too is person is a defined term. So it's meant to be quite broad. And I think that's probably the ROLCA mentality on that, as opposed to using the word member.
So if it's to any person on account of a transferable interest, then that will be the same as to or for the benefit of a member.
Yes, and they also use or in the person's capacity as a member. So I think it's intended to encompass both a new person and an old person, if that's the right way to put it. But anyway.
And thanks.
David, why does it need to be a transferable interest? What if there's the prohibition on transfers in the agreement?
So we will talk about that in a few minutes.
Okay.
So transferable interest is a defined term in ROLCA. And it's fairly broad, but we'll get to that in a couple of seconds. So,
okay.
But you're welcome to intercede at that time.
And the second room in that, the members' relinquishment of any right. I guess I haven't seen that in any other act. Is that? Have you seen? Has anyone else seen that in anybody in any other Delaware Act, Washington Act, any other act? Really know what it means?
Which part? Sorry.
The Roman numerat 2, the transfer of it to a member in return for the member's relinquishment of any right to participate.
I haven't seen that, but
It seems odd.
let me see what they have.
I don't know what they're getting at. I don't know what the purpose is. And why that would be a distribution. It doesn't seem like it's.
It looks like kind of a redemption sort of thing, but I guess there's maybe still a member, but just maybe not, I don't know, that don't have rights in management. I don't know.
Like if you give up management rights in exchange, for example, for money, that qualifies as a distribution to you.
Or if you agree to amendments to the LLC agreement in return for a distribution.
So the commentary doesn't really talk about that either. The only thing the commentary talks about is the fact that distributions have to be equal, but you're free to override that in your operating
agreement. Yeah.
So I guess mostly to your point, if somebody's a manager and says, okay, I'm not going to be a manager anymore. If you guys give me $1 million, then that $1 million would be the distribution under this definition.
I guess I'd argue no, because he's a manager, or if he's
Well,
perhaps.
if he was a member and a manager, but
Oh, okay, well,
and
yeah,
he
I think
says, okay, I'm going to step down, but you guys need to pay me $1 million.
that would work for me.
I always thought that distribution was kind of broader.
I can't hear.
Roberta, you
Roberta.
just broke up.
And
Oh,
she's
she's
frozen with a very questioning look.
Okay, I'll put in my headphones. Actually, I'll turn off my video because that way you can't see my questioning look and you might be able to hear me better. So I always thought distribution was a very broad term that would encompass almost anything that comes out of the entity. So, but it seems that many people here are thinking of it more narrowly, and I wonder why.
I've always thought of it as really any cash or property being distributed to a member in respect of that member's interest.
Yeah, I've kind of thought about it that way myself.
Including a redemption.
Right.
And redemptions are always included. But again, it's just, I've never seen this second Romanette. I'm just trying to figure out what it means and the purpose of it.
Well, I don't know if we need to dwell on it too much, because I agree with your, Cliff, with your understanding of what a distribution is. And 4A says the term includes, so it's just giving you some illustrative examples of what is meant by distribution. So I don't see this as restrictive or expanding what anyone understands a distribution to be.
I guess where I'm kind of getting hung up is if, let's say they give a member who's a manager or even an employee of the LLC a termination payment or a payment for a release, it seems like that all of a sudden would be considered a distribution. And I don't know if that's the intent of this section.
Why is it problematic if it is considered a distribution?
Well, my understanding is whenever you look at it, the whole purpose of having this definition is to determine whether or not a company can make a distribution. And if a company is insolvent, it cannot make a distribution. And if you get into a situation where a company wants to enter into a release with a member, but it's insolvent, then all of a sudden you're putting whoever's making that decision to sign the release on behalf of the company and make that payment, you're essentially giving them personal liability for doing so. I don't think that's a good conclusion. The way I'm reading this, and again.
But also I would have to think be by the sub-Romanette 2 would have to be limited to relinquishment of a right to participate as a member in the management or conduct of the company's activities and affairs, or to have access to records or other information concerning the company's activities and affairs. So I agree with you that a distribution under those circumstances, I think the company would be well served not to make that distribution, or agree to do that. But having said that, I'm sure some do on occasion.
Well, it's the member that's paying that you're trying to get rid of, and the company's not doing well, but it wants to pay the guy off to essentially
Shut
get up.
Right?
Yeah.
I don't know, Cliff. So would this be possibly encompassing something if an LLC wants to change from being a member managed LLC to being a manager managed LLC? Would that be a context where this might come up?
Or you're just replacing managers even.
Right.
Right. And again, I don't know that that's the right way to deal with it, especially if you've got the manager's good friend who's like, oh, he shouldn't be removed, but 4 other members think he should be. It leaves places to challenge it.
Well, I also think
Go ahead, David. Sorry.
I was going to say the most likely context where they're trying to persuade a minority member to get out of the limited liability company because that person creates all sorts of issues for them.
Not necessarily get out, just get out of the management part.
Right, not a full redemption.
Or on the other side of it, David, it could be for almost the majority owner, where you've got a majority owner that set up the entity that is just running it into the ground, who raised money from a bunch of investors, and the investors are saying, wait a minute, we're basically insolvent now, but we want you out so we can try to turn this thing around and make something of it. But then any payment we make to you is going to be considered an illegal distribution.
Again, I think though that would prevent them from dealing with that issue in that manner. They'd have to figure out a different way to replace that person or limit his or her involvement in some.
So you're limiting their ability to give the guy some cash. You're reducing the number of tools they can use to buy it. And guys, I don't want to kill this. We can put a pin in it and I can get more thought, but
yeah, I guess for purposes of what's before us, if there's a recommendation about language, or not including the language, then I think we can act on that. But I'm inclined to go with David's recommendation with respect to the language that's before us right now.
I would actually like to delete that subsection. I just don't see a need for it.
So I guess,
nor do I think it's consistent with any other act that I've seen.
So I would be actually in favor of keeping it, but on the other hand, I didn't look at what other states, like the state of Washington, done with that back to that definition. So it may be interesting to see what a couple of other states have done in terms of adopting it or revising that ROLCA definition.
So David, do you and Cliff want to confer about this and circle back to the group next month?
Sure. Yes. If that works for Cliff, it works for me.
I think that's great. That is one of the things we're concerned about, this a potential conflict with the 405 and 406 is that what we're concerned about, which is the limitations on distribution.
It's
Roberta,
exactly. I think that's really the place where distributions where it comes into play. That definition comes into play.
Okay. So if you guys could update us next time, that would be great on where you come to on that. Okay. Continue.
Okay. Next definition is subparagraph 5, which is the definition of foreign limited liability company. The similar statutory provision in Oregon is ORS 63.00111. They're not materially different in my opinion, and so I would recommend that we adopt the ROLCA definition.
Okay.
The next definition is subparagraph 8, limited liability company. Actually, 6. Oh,
Are we doing jurisdiction or
yeah,
jurisdiction?
I'm gonna get back. I'm gonna follow up on the next round on those. So the ones I'm talking about now are just the
Oh, I
definition.
see. Okay.
They're the corollary definition and the Oregon limit. Yeah, that one we will have to talk about that. I mean, ultimately, I think I would recommend that we include it, but that'll be in sort of part 2 of the discussion.
Okay.
The next definition is definition of in subparagraph A, which is the definition of limited liability company. And the corollary provision in Oregon is ORS 63.00117. And again, I don't perceive that they're terribly different than between the two. So I'd recommend the ROLCA definition. The ROLCA definition does exclude, in essence, foreign limited liability company, but as you see, they define it anyway. So my recommendation, again, we use the ROLCA definition of limited liability company. The next definition for which there's a corollary in Oregon is the definition of manager in subparagraph 9. And the corollary to in Oregon is 63.00119. And again, I don't really perceive that there's a significant difference between the two. The ROLCA definition is a little bit more, conforming to the ROLCA statute entirely. In fact, there's even a reference to section 407C in it where there's nothing like that in the current chapter. But again, consistent with our policy or our desire to adopt the ROLCA provisions, unless there's a policy reason not to do that, I recommend that we adopt the ROLCA definition of manager. The next one is subparagraph 10, which is the definition of manager managed limited liability company. And the corollary to that is ORS 63.00120. Again, I don't see any significant differences between the two definitions. So I recommend that we adopt the ROLCA definition of that. The next one for which there's a statutory corollary is the definition of member, which is in subparagraph 11. And the corollary in Oregon is ORS 63.00121. And they're a little bit different between the two of them. But again, I think the differences relate to how the ROLCA is drafted in the first place as opposed to the Oregon. But otherwise, I don't think there's a material difference between the two definitions. Okay. And again, for that reason, I recommend that we adopt the ROLCA definition of member. The next one, which there's a corollary, is the definition of member managed limited liability company. And the corollary here is ORS 63.00122. And ROLCA just defines it as a limited liability company that is not a manager managed limited liability company, whereas subparagraph 22 of our act defines it to mean a limited liability company other than a manager managed limited liability company. So again, I don't perceive that there's any significant difference between the two definitions. So I recommend that we adopt the ROLCA definition. Okay. The next one for which there is a corollary is the definition of operating agreement. And the corollary here is ORS 63.00125. Now, I think in the past we've had some discussion of this, what the definition of an operating agreement is. And I, for the life of me, can't really recall where we went with that. So
and I think we were going to circle back with this just to make sure people were comfortable. I think it's at 105.
Yes.
After we get through the rest of the core provisions.
Okay. So ROLCA defines it to mean the agreement, whether or not referred to as an operating agreement, and whether oral, implied, in a record, or in any combination thereof of all the members of a limited liability company, including a sole member, concerning the matters described in section 105A, and includes the agreement as amended or restated. The current act defines it to mean any valid agreement, written or oral, of the member or members as to the affairs of a limited liability company and the conduct of the limited liability company's business. So again, I would recommend that we adopt the ROLCA definitions, quite a bit more expansive, subject to us being comfortable with any limitations or whatever the matters are described in section 105A. Again,
oh, go ahead.
in preparing for this, I couldn't recall what our discussions were with respect to section 105A. So I don't know how that's impacted, but for our definitional purposes, it probably doesn't impact it at all. It's whatever
I think
105A is.
that's a really good recommendation, because I think that the ORS definition saying valid agreement, that raises an issue, right? What's valid?
Yeah,
So I think it's much better to use the RELCA version.
No, I agree, absolutely.
Yeah, I don't know what work the word valid is doing. It's not an operating agreement anymore if it's an invalid one.
I don't know what the reason for putting the word valid in there was in the first place. It's kind of interesting. The next definition for which there's a corollary is the definition of organizer. The corollary is OR 63.00126, and there's no particular real difference between the two definitions. So I would recommend that we adopt the ROLCA definition. The next one for which there is definition of the word person. Our act is not really, it does have a definition of person, but it's a more complicated, in a way, complicated definition. And I think the ROLCA definition is really where we need to go on this. So in Oregon, you have, under ORS 63.01, you have a definition of individual, you have a definition of entity, and then they describe in subparagraph 28 is that a person means an individual or an entity. So the effect of this is to basically, I think, at least the way I read it, is that, we're defining person to mean everything that's already listed in ORS 63.001, subparagraph 9, 16, and 28. So to me, it's a better definition, a simpler definition. I'm not really quite sure why Oregon broke it down and that the definition of person into and separately defining individual or entity. So, but I think the current definition in subparagraph 15 of ROLCA, section 102, encompasses everything that's currently in ORS 63.001.
I suggest that we add a comment here, like we were just talking about in the other definitions section, that business corporation includes a professional corporation.
That's a good point. And the entity under the Oregon Act includes specifically a professional corporation. So,
Okay.
David, it also mentions tribal governments. And I guess that's included, and foreign governments for that matter. Is that included, do you think, in generic government?
yeah, I think it does, but if other people disagree, because I think it's the definition of person in ROLCA is meant to be very, very broad. But if they think there's a policy reason for it, we should include some of the other entities listed under the definition of entity, then I certainly wouldn't have any objection to that.
And we think that other legal or commercial entity is going to encompass professional corporation, right?
Right, but I think we're flagging this one for legislative council to see if they care. And I just made a note about that.
So my other comment is we do not adopt the definitions for entity or individual currently contained in the Act, other than with respect to any concerns that the current definition, the new definition of person would not include some of the entities listed.
Sorry, what?
Well, if we wanted to specifically include, a federally recognized Native American or American Indian tribal government or any foreign government or something to that effect.
Oh, yeah, no, I put a note saying that for legislative council, when we send this to them, we'll comment about the professional corporations or tribal governments, just to see if they think it's, relevant and important to include those additional buckets. I think they're probably subsumed within what we've got here, but again, I don't know what they're going to view as important.
Okay, so the excuse me. Next definition for which there's a corollary under the Oregon statute is definition in subparagraph 16 of principal office. And the analog there is 63.00129. There's not a significant difference between the two definitions with one exception. And I think that we would have to take into account the one exception. And that is, I would recommend that we adopt the ROLCA definition, but I also would recommend that we add the second part of ORS 63.00129 relating to commercial mail receiving agencies, mail forwarding businesses, or virtual offices. That was clearly added.
Transparency issue.
Yes, and on purpose, I can't remember, it was a couple of years ago or so when we adopted all the shell company stuff. So I think we would have to add that to this definition.
And that's 63001 sub what?
29.
Okay.
Current Oregon law also refers to a physical street address.
Right, and that was a big deal when they added that too. So I think.
Oh, you're right. That's probably that's a good catch. So
yeah, so we'll just pull in whatever the current principal office stuff is for transparency reasons.
So
Well,
maybe
I was wondering,
early that we just adopt the section 20, the ORS version at this point. I'm sort of changed my mind.
well, maybe we should check. My memory is that when we were talking about the things that affect the principal office, I may be wrong, but maybe we already added that you need to have the street address there such that it would be redundant to list it.
I kind of recall well, but I don't know where that would be though. That's the.
I think we did consider all those factors of making sure that all the shell company conversations, street address back then. I agree. I just remember that too.
Maybe somebody could just check this like after the meeting and make sure that we have that street address, physical street address aspect of it captured in the substantive sections if it's not captured here.
Right.
Well, I think we should capture it here as well, although maybe it would be redundant if it's someplace else.
Well, I don't think there's any problem with redundancy. I do think that this is something that legislative council is going to need to weigh in on, because the intent clearly is that we have is clearly to capture all of the changes they made for transparency purposes.
Yes, I think that's imperative.
Your business office, along with 999 other people, is a trailer in Vernonia, then maybe it's a problem.
One used by hundreds of thousands of entities.
Yep. So the Oregonian found.
Yes. So the next one, for which there's a corollary, is subparagraph 19, which is the definition of, actually, there really isn't a corollary, but I take the position that there probably is definition of registered agent. So we don't include in our definitional section a definition for registered agent. So ROLCA, however, ROLCA does it. So the closest thing we have is ORS 63.111, which sort of deals overall with registered agents and the requirements for them.
Mm-hmm.
I guess I didn't have an objection to adding this definition.
I don't have a concern, but I wonder if Secretary of State's office does. Kevin, do you have any thoughts on this? Maybe, no. Because Jamie had to step away, so it looks like Kevin may have us on silent. Okay, well.
But we could pin that.
Yeah.
For Jamie to look at.
Yeah.
The final definition for which there's a corollary is the definition of state, which is in subparagraph 22 of ROLCA. And the corollary is ORS 63.00132. Section 102 is, they are different, but again, I don't know whether I would view them as materially different. But ROLCA does go into point of referencing the District of Columbia, Puerto Rico, the Virgin Islands, et cetera. But I think the ultimately, I don't have any objection to adding those. I wonder why their reason for adding that was. But whereas ORS 63.0132 is to mean a state, commonwealth, territory, or insular possession of the United States and the agencies and governmental subdivisions of the state, commonwealth, territory, or insular possession. So anyway.
Yeah, I think it's fine.
Yeah, I think so.
I don't know why they didn't mention Guam, but you know,
That's true. Maybe we should have Guam.
Northern Mariana Islands.
Yeah.
Samoa.
Right. But no, I think it's fine. And if legislative council doesn't think it's fine, they'll let us know.
So I misspoke. Actually, the last one for which there's a possible corollary is the definition of transferable interest in subparagraph 24. And my guess is the closest analog in our statutory set of definitions, 63.00123, which is the definition of a membership interest.
Okay.
ROLCA doesn't really use the phrase membership interest so much as it uses the phrase transferable interest. So I guess, I would recommend that we go with ROLCA and not adopt a separate definition of what a membership interest. Also, the other area that deals with sort of what a membership interest is ORS 63.239, but I don't recommend that we adopt that either. But instantly, ORS 63.239 just basically states that a membership interest is personal property, but that's already in ROLCA in section 501. So this would just.
Sorry, I think it's sort of funny that they call it transferable interest. Can't LLCs provide in their operating agreement restrictions on transfer?
Yeah.
Like,
Absolutely.
So then it seems weird that they call it a transferable interest when it might not be transferable.
Well, I think it maybe is
main change that I see from
to include something more expansive than just a membership interest. It could be something, maybe like a profits interest perhaps, or something to that effect.
But what if it's not transferable by the terms of?
Then, I mean, you can amend any of these definitions, right, in the operating agreement. So I think this is our carpet layer situation.
Well, I don't think that the operating agreement amends the definitions per se. I mean, even
No,
if
but you can
it's just,
impose
it's ultimately the
restrictions on
substance that
transfer.
matters. Like,
Right. I mean, I think what Roberta's commenting is just that the language seems odd in situations where you may have restrictions on transfer. But I
Yeah.
don't know that that's a deal breaker for using the term.
Right. Well, I think that theoretically all interest would be transferable, unless I would argue that the operating agreement states otherwise.
So I think there's a distinction between a right to receive distributions, which is what a transferable interest is, and a governance interest, which is the other stuff in the bundle of sticks. And I think, I haven't verified this, but I expect that ROLCA's default provision is that you can pretty freely assign the right to receive money, and thus it's called a transferable interest. But governance is probably harder to transfer and requires more other people consenting. And I suspect also all of this can be overridden in the operating agreement.
That's an interesting observation, because I don't think I've ever seen where you've sort of included as a transferable interest some part of the governance part of a limited liability company, but that may only be limited by my own personal experience. So,
well, we have tons of operating agreements where if the agreement, all the transferee gets is economic rights, or we have some definition for it, you don't end up becoming a quote unquote with what is effectively governed after the LLC approves and 2/3 of members or whatever it is.
right, I've seen that as well. So
So is that the last corollary section, David?
yes.
Okay, why don't we take a 10-minute break for people to go get more coffee and do whatever, and then Sandy?
Yep, we're back on.
Okay.
So I'd argue we're almost done. So in theory, for some reason, I'm losing my voice, so that
Oh, no.
it'll make me have to go even faster. So the next part of the definitions in section 102, for which there are not any similar definitions in ORS 63.001. And there's 1, 2, 3, 4, 5, 6, 7, 8 of them. They include jurisdiction, which is used to refer to a political entity, means the United States, a state, a foreign county, or a political subdivision of a foreign country. The second one is subparagraph 7, jurisdiction of formation, which is defined to mean the jurisdiction whose law governs the internal affairs of an entity. Next one is subparagraph 17, which is property, which is defined to mean all property, whether real, personal, or mixed, or tangible or intangible, or any right or interest therein. Next one is subparagraph 18, which is record, which is used as a noun, means information that is inscribed on a tangible medium or that is stored in an electronic or other medium and is retrievable in perceivable form.
As opposed to an imperceivable form?
I guess, yes. The next one is subparagraph 20, which is registered foreign limited liability company, which means a foreign limited liability company that is registered to do business in the state, essentially. Next one is subparagraph 21, which is sign, which is defined to mean with present intent to authenticate or adopt a record, to execute or adopt a tangible symbol, or second, to attach or logically associate with the record an electronic symbol, sound, or process. Next one is a formal definition of transfer, and it lists a number of items, including an assignment, conveyance, sale, lease, encumbrance, gift, or a transfer by operation of law. And the final one is a formal definition of transferee, which is defined to mean a person to which all or part of the transferable interest has been transferred, whether or not the transferor as a member. And then it also says that the term includes a person that owns a transferable interest under section 603A3. So I don't perceive there's any reason why we shouldn't adopt these, as they would be used throughout the ROLCA as we're going to adopt it. So they'd be convenient. I mean, it would be consistent with our adoption of ROLCA as a whole.
My thought only is that we probably want to put a flag again for legislative council on the jurisdictional issue about to make sure it includes tribal governments.
Oh, okay, that sounds good.
And I have a note probably from 2 years ago saying as to the definition of sign, somebody had thought that we should keep in the commentary or put into the commentary a reference to the Electronic Signatures Act.
Mm-hmm.
I don't know if that's necessary or not, but that's what we had said a couple of years ago.
Yeah, the only note I had from like a couple of years ago was something to the effect of, we also talked about this definition. It says like for blind and deaf people. So that was the only thing I had found.
I think we
I'll
can
flag
do
one
without the comment, but
I don't think we need to account for the Electronic Signatures Act, because I think all that says is that a signature provided in electronic form counts as a signature, and this wouldn't conflict with that in any way.
That makes sense to me.
So Oregon does accept for filing documents that have been electronically signed.
Yeah.
Wherever it's worth. So anyway, so my recommendation, we include these definitions in our proposed bill.
That makes sense to me.
The final part is the definitions in ORS 63001, for which there are not any similar definitions in section 102. And some of these I think we would want to consider including in our proposed bill. The first one is ORS 63.001 subparagraph 1, which defines the term anniversary. And I only flagged that one because that appears to be something that the Secretary of State may want to weigh in on. And it means the day each year that is exactly 1 or more years after the date on which the Secretary of State files the articles of organization for a domestic limited liability company, or the date on which the Secretary of State files a foreign limited liability company's application for authority to transact business in the state. The only reason I say that, I think that may come into play with respect to the filing of annual reports and that sort of thing. And that, I don't know whether that definition will follow through, but I think it's something we should, carry through if it's important. So anyway, that was one I would flag.
so like I just did a word search in chapter 63, and the only time anniversary is used is in 787 involving the annual reports, which is covered by section 212 of ROLCA. And
Does it use the phrase anniversary there?
ROLCA doesn't, but I guess more importantly, my notes indicate we decided not to adopt section 212 of ROLCA and instead keep ORS 63.787.
Which means
Oh.
that we should keep the definition
keep
anniversary.
Yes.
Yeah.
So I just want to note that James put something in the chat that maybe we should talk about, because he's having internet problems, and I understand that because I do too.
I don't know if this works better. I was just flagging that the definition of transfer includes a pledge of a security interest. And I haven't studied how that plays out, what's generally permissible and what's generally not permissible, but I wouldn't want by accident to change what we're doing. If we're changing, we should know we're changing.
That's interesting. So I don't, so I would argue that under the new ROLCA, that, you know, that would be, a pledge would be a transfer membership interest, because it includes a encumbrance, including a mortgage or security interest, and obviously that would be an encumbrance. So
yeah, and under 502, it says a transfer in whole or in part of a transferable interest is permissible. So I think the default under ROLCA is that you can transfer, which would mean you can pledge. And I don't know if that's necessarily true under Oregon law. Again, I haven't studied it. I just spotted the site.
So I'd rather have the more expansive view of ROLCA, I think, in my view. So
Well, and I wonder, so Teresa had originally handled Article 5, which means that Tara is going to be taking over sort of the review of it. And I wonder if this is something that we should refer to her for consideration.
sure, that would be great.
So I just did a search on pledge in ROLCA, and it says that the definition of transfer is blah, blah, blah. This is on page 123. And it says a charging order under 503 affects a transfer of part of the judgment debtor's transferable interest, as does the pledge of a transferable interest as collateral for a loan. So I don't know if that.
Well, right, because I think that ROLCA has a more expansive definition of what's permissible in that circumstance, right?
Yeah.
Than current chapter 63. But I wonder if this is something that we can ask Tara to consider when she goes back and looks at, you know, how this would actually play out relative to 502.
I think that would be prudent. Commentary on definition of transfer doesn't offer much in terms of guidance.
Mm-hmm.
And the part about 249.7 saying that, I mean, you know, it starts out, 249 starts out saying, except as provided in the Articles of Organization or Operating Agreement, the pledge is not an assignment. So it's something where parties have control over it, at least under Oregon law currently.
So
Right,
I can't,
and
that
sorry, go ahead.
operating agreement would not contain a prohibition against, you know, granting a security interest in the, I mean, most of them are that way. Obviously, they could be drafted in a different manner.
Okay, so we'll ask Tara to take a look at that. Sandy, would you please make a note about that, just so we can refer her to this discussion if she needs to.
Yep, I got it.
Okay.
So the next definitions are ones we've actually put quite a bit of discussion about. And they're the, so, or again, 63.001 contains a definitions of a corporation, domestic nonprofit corporation, domestic professional corporation, foreign limited partnership, foreign nonprofit corporation, foreign professional corporation, and limited partnership. My initial recommendation would be not to include those definitions and just simply go with the definition of person. However, we end up having person defined in our proposed legislation, as opposed to leaving those or adding those separate definitions to our proposed bill.
Which word is that again? Sorry.
So they're all the ORS 63.001 contains separate definitions for all the various entities. They're included in subparagraph 5, 7, 8, 10, 12, 13, 14, and 18. And again, they include corporation and domestic corporation, domestic nonprofit corporation, domestic professional corporation, foreign limited partnership, foreign nonprofit corporation, foreign professional corporation, and limited partnership. So,
yeah, I agree. It makes sense to axe all of those.
right. Okay. Perfect.
Thanks.
The next one is ORS 63.001, subparagraph 15, which is the definition of incompetency, which is defined as the entry of a judgment by a court of competent jurisdiction adjudicating the member incompetent to manage the member's personal estate. I do not recommend that we include that definition because it really is not, the word incompetency, at least I didn't find it, was not used in ROLCA at all. Section 6027 provides that an event of dissociation includes a member in a member managed limited liability company, the appointment of a guardian or general conservator for an individual, or an entry of an order by a court that the individual has otherwise become incapable of performing to the individual's duties as a member under the act or the operating agreement. Under our current act, incompetency would be an event of, I know we don't use disassociation event, but it would be essentially that. And they list in the statute later the word incompetency. So unless people disagree otherwise, I would recommend that we not include that.
Good.
But ROLCA does talk about incompetent. It doesn't talk about incompetency, but it does have a few mentions of incompetent.
Within the statute itself or in the commentary?
Good question. No, within the statute itself, actually, and this, I don't even know where I am.
Section 203.
203, yeah. 203.
Oh, I could have sworn I looked at
B. It doesn't say incompetency, it just says incompetent. So if a person is incompetent, a record can be signed by a legal representative, and then it, I agree, I don't think it defines what incompetent means. It says deceased or incompetent. I don't think we need to define deceased. Although maybe, I don't know. It could be a medical issue.
Probably mostly dead.
It is not the same thing as all dead.
So I would also argue, I don't think we need to separately define it, even in that context.
I agree.
Well, no, and I think that there are other statutes that deal with this issue probably more comprehensively.
I agree.
Okay. Good.
So we're coming to the, and so the other definitions, I sort of put them together, are the definition of office, party, proceeding, and United States. I have recommended that we don't include those. I did sort of search through ROLCA. They do use those words quite often throughout the ROLCA, but they never ever define them. And the interesting thing is, like, party is like deemed to be a person who's a quote party to a proceeding. But, and again, ROLCA uses, and I also didn't see any reference to office.
Office in what?
So let me get that.
Because I think we would be looking in chapter 63 for instances of the word office.
So office is defined in our current act is when used to refer to the administrative unit directed by the Secretary of State, means the office of the Secretary of State.
Right, but then I just mean, are there instances in ORS 63 where this word office is used and there's some substantive importance of that we need to have that substantive importance captured in ROLCA somehow, which we might otherwise miss because we don't adopt the definition of office in ORS 63001. Like, at least that's how I would approach it.
That's probably a good, but I think I recall looking at that yesterday. I didn't see anything that was of substance, but but now having said it, we may want to pin this one.
I think where it's most likely to show up is in with respect to, registered agent office and other points
Right.
that the Secretary of State's office may, may need to contact someone or may have rules about that. I don't know, Kevin, are you back? No, okay. So, we may want to ping the Secretary of State's office to see if they have thoughts about that. I mean, I think that's where it's most likely to be an issue.
It looks like it's in 63.004 filing requirements.
Right.
So I think they're just using sort of office like we use service for the Internal Revenue Service, basically.
I think so too. And I don't know whether that really translates into the new act, the ROLCA.
I mean, it might be something, again, we just flag for legislative council and say, do we need to have this separately defined? I mean, I think with that list that you have, David, I mean, do they need us for purposes of the LLC Act to define the United States, right? I mean.
Right. No. But it is interesting because I did search through like on person or party and proceeding. That term, those terms are used a lot at ROLCA, but they're all remain undefined and they're all lowercase.
Right. I just think that with all these, I'll give you for example, ROLCA doesn't define the word individual and ORS does.
Yes.
So if you run a word search in 63 for the word individual, you notice that there are 4 statutes where, for example, under 63.111 and 721, a registered agent for a domestic or respectively foreign LLC needs to be an individual. Whereas ROLCA's provision, section, I think it's 115, says a registered agent can be an entity or, any person. And so ROLCA is allowing your registered agent to be a non-individual, a non-natural person, whereas ORS does not allow that. So like, that's something that I think that's why I think it's for these words that are defined in ORS, but not in ROLCA. I think the question isn't, I mean, it's in part, is that word used in ROLCA? But I think even more importantly, the question is that word used in the ORS chapter 63 in a way that creates a substantive difference between ORS and ROLCA? And I noticed like the word office appears in ORS chapter 63 151 times. So that's a bit of a slog to find out if there are instances where it's important to have a certain definition for the word office, at least to find out what is the policy of Oregon in this regard.
Well, and I think also I would wonder whether we've adopted section 206 of ROLCA, which is the filing requirements, or if we decided to go with the ORS filing requirements, which is 63.004, because I think that might inform our decision as to whether we want to define office or not. ROLCA doesn't use the word office at all in the filing requirements. It instead talks about the Secretary of State. And ORS talks about the office of the Secretary of State and then uses the term office later on in that provision to mean the office of the Secretary of State. Because ROLCA does define principal office, right? And I think, David, we agreed that we're going to use that ROLCA definition. And so I think probably a lot
I think we're going to use for the most part, we're going to use the Oregon definition of it because has all the transparency rules like a physical street address and.
Right.
Okay, right.
Well, so the ROLCA definition, but with the Oregon add-ins is my recollection.
Well, with the Oregon Part B added about what it's not. And then I thought we had decided that somebody was going to look into whether there are provisions of ROLCA, because I think actually we've already talked about, with regard to the filing requirements and so forth, where you have to list this principal office. I think we might have put in our version of ROLCA, go and add in certain sections from the recently enacted sections from ORS that talk about requiring a physical street address.
Yeah.
So I guess in short, like.
Oh, you're right. We did talk because it might be just.
Yeah.
Our definition then.
Yeah, and well, it looks like on 206 we've adopted it largely. We had a bunch of script. I have a lot of cross outs in certain sections in 206. So, but really, it's the job of legislative council to go through and smooth out, style and form and make sure all the definitions are there that we need to have there, but
Right, I just think that it can be the case that I agree with you, legislative council looks at style and form,
yeah.
but for example, something like, individual, where there's an actual substantive requirement, I think it's helpful for someone on our team to look through these words that are in ORS but not ROLCA to make sure that those definitions don't lead to substantive policies that we might otherwise overlook.
No,
So
I agree with that. And I think that should be front of mind as we're each going through our individual sections. So David, as part of the follow-up for this meeting, I think the list of terms that are not in ROLCA, if you could email those to Sandy, and Cody will email the sections that he's identified to Sandy, and Sandy will circulate those to the group so that we can, as we're going through each of our individual sections, keep those front of mind about whether we need to incorporate them.
Yeah, thank you.
Cody raised a good question about the word individual, because I guess I didn't realize that if you're a foreign limited liability, you can't use an entity as your registered agent. So I would hate to have that rule, actually. So
well, and Secretary of
think
State,
that's
I'm sure,
true.
is going to weigh in on a lot of this as well.
Yeah, James made the point in comment that you can actually use an entity as a registered agent, and he's given a site in the chat.
Thank you, James.
oh, okay. So maybe
Yeah, I agree with you, David. That would be problematic.
yeah, because everybody uses these, like CSC or something like that.
It's an or. I see that in 111. It's you can be an individual or these other things. Yeah. There's also, for example, on who can form an LLC, I think maybe like who the organizer is. Oregon statute says it has to be an individual over 18 years of age. And, ROLCA says you don't have to be a human, you can be a non-human entity to be the organizer, I think.
Well, that's interesting because the definition of organizer in ORS subparagraph 26 just means one of the signers of the initial articles of organization. So that rule must be someplace else.
Yeah, I think, yeah. And I don't necessarily, we can talk about individual and its definition right now, but I just was thinking mostly that we should just check the ORS for instances of these unique ORS words. For example, 63044, I think we decided to, well, I can't remember what we decided to do, but it talks about one or more individuals 18 years of age or older or other entities may form a limited liability company. So you can have a non-individual do it, but if you're going to have an individual do it, they have to be over 18. And my recollection is that we decided to just kill that age requirement because nobody checks it anyway. Like the Secretary of State, I think, authorized axing that because they don't check it.
I have a lot of 17-year-olds running around forming entities.
They're just, saving money to go to college.
All right.
Okay, we have one left, which is the ORS 63.00131, which is the definition of shell entity. So my guess is we probably
we'll keep that one.
Yes.
Okay. Is that it?
And that's it.
Great. Okay, so I think, so David, you'll send out those definitions to Sandy. Cody, you'll send your notes to Sandy. But then I think as we're going through and looking at each of our individual sections, which I'd like us to, and tell me if you think this is way off base, but I'd like us to do just a quick pass through each of the sections and have people circulate the cleaned up version, just to make sure that everybody's notes are incorporated into the cleaned up version that we're going to send to LC. And then, so we'll go through those over the next couple of sessions. And then I think after March, we should be able to get this to Legislative Council, who hopefully will be recovered from session.
And what might be helpful, Valerie, is, and I've shared, so I did convert, I have all of ROLCA converted into a shareable Word document, which I've distributed before, and I can do again. If people just want to dump your notes for your section into that document, I can then arrange it into something that's more usable.
Yeah, sure.
I think that would be awesome.
Yeah, which I'm very happy to do. So I'm gonna share that with the whole group again. It includes the whole of Roca. It'll be editable by all of you with the link. Just dump it in there and I'll make it look better so that our next meeting, we can use it as a framework for discussion.
Perfect.
Question for Valerie or Sandy is there a master record of, as we've gone through and say, we're going to change this and that? Is there sort of a master record of our decisions?
Well, Sandy's been keeping notes.
I've been keeping notes. I can't claim they're perfect. I will keep working, especially ahead of our next meeting, which I have a date, to add every notation that I have in those particular sections on that document, which I please ask you to correct me if I heard wrong, because as not being a subject matter expert in this area, I can only listen the best I can, but I at least have notations of everything that I've taken down.
Well, and I would like next time for us to have gone through at least the first 5 articles, because we've got essentially two sessions to just go through and make sure everything is captured. So if we can do that in, not talk, like have in advance of that, Sandy, so maybe in the next week or two, have your incorporated comments, we can incorporate our comments into those first 5 articles.
That actually seems doable for the first 5, because I actually already had done the first 2 or 3. So yeah,
right.
I can
and
do that.
So if you could circulate that, then we can incorporate our other feedback and get those cleaned up enough that we could then send them to Legislative Council after session.
I feel like that's very reasonable for the first 5. Yeah.
Okay. Does that sound doable for everybody else?
And I'll get that link out to everyone today.
Okay. And I think that will be better than having, obviously you want the people who presented on them to have the most detailed feedback on those sections, but I know that some of these sections were a lot longer than others. So to help distribute the workload a little bit, I think I want everybody to be able to comment on the edits. Okay.
I'll set it so everyone will be able to edit every section of the document. It won't be
like in a Google Doc or something.
It'll be a through Microsoft platform, just because that's what we have at UO, but it's the same idea as Google Doc.
Right. So it'll show who's making the edits.
Exactly. Okay. You have to log in with your account to show who it is, but it's easy to do.
Okay. Sounds good. All right. Anything else for the good of the order? We'll finish up a little bit early today, which I'm sure will be good for everybody.
Thank you all for your commitment to the project and for understanding a bit of a break. And seriously, with Mosen's request, this group's been so awesome to work with. If any of you have any interest in working with UO and you can be in Portland, let Mosen know, let me know, and we can get you connected with the right folks.
Let me know when you increase the tax offerings in the Portland program.